Our first session is on constitutional dimensions of criminal process.
To shed light on the significant topic, we are honored to have with us Professor Dr. N.S. Soman, visiting faculty at TNNLU, Trikey, retired Dean CUSAF. He is skilled in research, legal advice, curriculum development, teaching and higher education in law. He has a strong education professionalism with LLM, PhD focused in criminal law and constitutional law, jurisprudence from School of Legal Studies, CUSAF.
So please address the participants with your lecture.
Welcome, sir. Welcome to our FDP, sir.
Yeah, thank you.
Sir, you may want to switch on your camera, sir.
The camera is on.
Okay. It seems then you are not visible.
No, it is on now. I can see my own picture here. It's not visible.
No, sir. You're not visible, sir.
I don't know what to do with because it's been seen here.
Okay. Is it showing your camera is on as per the?
Yeah. Camera is on. Audio is also on.
Yes, sir. You are audible, but just not visible.
I don't know because I don't know the technicalities how to make it visible also. Then I switch on my camera and this disappears and put it on. The image appears also.
So, sir, when you are switching on your camera,
this image disappears.
Okay.
Then switch on, again it appears. This is what I could make out from the gadget jumping.
Okay. So, would you like to join through your mobile phone?
I'm through the mobile phone.
Okay.
Because otherwise this unpredictable power supply.
Okay, yes.
So I right now in mobile phone only.
Okay. So shall
I let me like that. We'll continue like this, okay?
Yes, sir. You are.
Because I don't know the technicalities how to make it
yes, no problem.
visible in that sense. And if I go for something, it may become more complicated.
Yes.
Sorry that I could not make it.
No problem, sir.
Then I just have a summary of what I want to convey.
Yes, please, sir.
Because I told that it is a constitutional dimension of the criminal process or criminal law as such. But I am not fully focusing on the substantive criminal law. That is also an area which could be focused for our talk, but more on procedural aspects, which is a focal point in national constitutions as well as the international documents which talks about the basic rights of human beings. Because in national level, all of us know that constitution is the touchstone of all legislative process, even the executive actions, because everything which is to be done by the two wings of government that should be in tune with what is being contained in Part 3 of the Constitution. The Bill of Rights or the fundamental rights, which has been part of the constitutional arrangement, is really been a restriction on the law-making power of the state, because Article 13, the right that states shall not make any law which is inconsistent with the rights which are contained in Part 3. So it's a prohibitory in nature, or mean taking away the otherwise power which is being vested with the legislatures. The same tone of protection of rights, which we could also see in UDHR, life, liberty and security of person, the prevention of torture cruel, inhuman, degrading treatment and punishment of persons. Right to get an effective remedy when the rights are getting infringed or being arbitrarily being denied. Prevention of arbitrary arrest and detention. Guarantee of a fair and public hearing. Presumption of innocence when a person is being charge sheeted for an offence which alleged to have been committed by him. And non-retroactive activity of criminal law is also forms part of the guarantees which has been envisaged in the privacy, family, home, correspondence, etc. also being sanctified areas where the state should not intrude into. All these provisions will have a direct bearing on the protection which is afforded while the criminal law process is on. The ICCPR, which is a binding document adopted in 1968 or so, the right to life and the desire which is expressed by the international community to restrict the imposition of death penalty for a most serious crimes, and anyone who is being condemned, the right to seek pardon and is also be a guaranteed right. And also further restriction is also been envisaged on imposition of death penalty on persons below 18 years of age, and also shall not be carried out in on pregnant women. And it's also further stated that the provision is there, it should be in rarest cases or be a small number of cases, only in graver cases death penalty is to be adopted. That should not be interpreted as a guarantee or be an authorization of reintroduction of death penalty in cases where it has already been abolished. Let it be there when it's abolished, because the general trend which has been shown by international documents is also see that death penalty is get abolished from the penal statutes. Prevention of torture, cruel, inhuman and degrading treatment or punishment is a guarantee of at least a decent treatment of the accused person, and also prevention of subjecting persons for experimentation, scientific experimentation without the consent. A guarantee of liberty and security of persons, prevention of arbitrary arrest and detention, and intimating the reasons for arrest when somebody is getting arrested, and informing the charges which are being leveled against him. And these are all the minimum guarantees which is supposed to be there in any civilized systems of criminal justice administration. And any person who has been subjected to arrest is guaranteed a right to be examined or be produced before a judge or other authorized officer who could exercise the judicial power to scrutinize whether the arrest is justified, and also the trial within a reasonable time is also a guaranteed right which is being envisaged under the international human rights document also, which of course we could also read it into the Indian scenario when you are examining the development which takes place in context of the national developments. And any person who has been arrested or been detained is guaranteed a right to question or get his detention or arrest being examined before a court of law, and he has got the right to take appropriate proceeding for the same. And a victim of any unlawful arrest and detention is supposed to be compensated, a provision which Indian government has been made as a reservation. But we know that the subsequent developments in Indian law made that reservation of having no legal implication, because the interpretation which is adopted to the Indian constitutional scheme itself made it possible for the courts to order compensation where the rights of the citizens are getting infringed or being violated illegally. And a person who has been subjected to deprivation of liberty is to be treated with humanity, and his inherent dignity as a human person has to be respected and protected. So the fact that he has been accused or been deprived of his liberty and now in incarceration is not a ground to deny him otherwise admissible rights as a person is concerned. And segregation of convicts from the under-trial prisoners, segregation of juveniles from the adults, speedy disposal of the case, etc. are also being forming part of the guaranteed schemes under the international human rights law. And the emphasis has also been given to see that rehabilitation is the ideal, not any other penal proceed. So social rehabilitation should be the aim in any deprivation of right, deprivation of the liberty is being because he has committed a crime. So that is also a message which has been made loud and clear by the international documents. A fair and public hearing before an impartial tribunal, a public judgment, except in case where the interest of juveniles or marital relationship, matrimonial relationships or disputes or guardianships of children are involved. Other cases, it's an internationally accepted norm that there shall be public trial and the condemnation shall be took place in public, not any secret process which should be there. And any person who has been charged, brought before the tribunal or a trial court shall be presumed to be innocent, which gives rise to many other incidental rights which we read in the criminal procedure as rights which are being inherently been there as an integral part of the trial process. And informing the basis of charge, nature of the charge, etc., which also been carried forward as the part of the binding document, and sufficient time for preparation of his defense, and to get the help of a lawyer and have a free communication with the counsel so as his ability to defend himself will be protected. And trial without delay, the speedy trial which has been read into Indian constitutional scheme through interpretation is an integral part of the international human rights standard. And trial to be conducted in presence of the accused person, definitely a facet of the common law right which a defendant can claim. Defending himself either in person or through the assistance of a lawyer of his own choice. The right to have a legal assistance in cases of no sufficient means to pay. That is a free legal aid is also been envisaged as part of the guaranteed rights for any citizen who is been facing the criminal trial is concerned. He could examine witnesses who are appearing against him, or also those who will be deposing in favor of him. That means there should be a guaranteed right that the process will be available for him also to bring the necessary witnesses to prove his case or to conduct his case, and equality arms, as we are normally been referring to, is also been a guaranteed rights. And in language barrier is there. Naturally, on a for a fair procedure, there shall be an interpreter who can tell the accused what is really been happening before the forum. And it's an express right in international human rights norm, but it can be impliedly been there so far as the Indian constitutional scheme is there. Protects against self-incrimination and review by the higher courts when conviction is there. And if there is a miscarriage of justice, compensation to be awarded to the person who has been subjected to such a miscarriage of justice because a wrongful conviction has been made. These are being enlisted as part of the basic rights to be protected under the international norm. And non-retroactivity of the criminal law is also being some part of the guarantees which is envisaged. And often an act which has not been offence at the time of commission shall never be made an offence subsequent to the event, because that can give a hand and a weapon in the hands of any authority to what the person is doing, then criminalize, then ask him to answer for things which he already done, which is society iniquitous and unjust. So such a practice is also not possible. It is being protected, prohibited, and except cases where there is a conviction or being trial on the basis of general principles of law relating to the international law principles generally accepted by the civilized community, when there is no need for this prior announcement because it's already been forming part of the existing legal framework. And this are the background in which the human rights has to be examined. And in interpretation of these rights in different contexts by the Indian judiciary, you can see that when the public servants, they have been immune, generally been against the possibly being prosecuted for actions which have been taken while discharging their functions. Sometimes they may be beyond what they have been done. The sovereign immunity principle has generally been accepted. We can note the decision in Amity versus State of Orissa, a 1993 decision, which made it clear that the basis of the compensation to be awarded to the victims of high-handedness of the executive. In that particular case, it was the case of custodial death, where the court will award compensation. There will be no admission of any plea of sovereign immunity when the question of violation of fundamental rights are being the issue which is to be examined by the court. That means there is a theoretical basis for the jurisprudence has been laid down in Nilavati. Therefore, this is an interpretation adopted by Indian Supreme Court, which is in tune with the jurisprudence which has already been developed in other context. But they explain what exactly can be the basis of such a jurisdiction which has been accepted or been regularly been admitted by the Supreme Court and various high courts, because it starts from Rudolph onwards. Large number of cases are there wherein the compensation has been awarded where the rights stand abrogated. And now they have made it possible on a theoretical basis that it is part of the remedy which arises from the public law remedy which is envisaged for anyone whose right has been infringed. Another dimension of the insistence of fairness in the criminal process we can read in Shamda Singh versus State of Punjab, 1976 decision, wherein the court made it mandatory that there shall be a pre-sentence hearing, and the pre-sentence hearing makes the procedure more fair, just and reasonable. And at that level, it has also been a sort of constitutionalization of the sentencing process in India. And there are a good number of other cases which fall in line with what has been decided by Shanta Singh in 1976. You can see variations from the general principles of criminal law, which has been accepted as a normal process in some of the specialized legislations, TADA, NDPS Act, SCST Atrocities Act, and the acts like that where there is a variation. Of course, we are not going into the details of such variations which comes in, but sometimes the constitutional validity of the things could also be tested, because in NDPS Act we can see there is a mandatory death penalty which has been provided. SCST Atrocities Act also there is mandatory death penalty, irrespective of the fact that there is constitutional decisions which made it impossible for the Indian Parliament to make any legislation providing for a capital punishment as a mandatory one. The Mito versus State of Punjab is declared. Irrespective of that, there is a tendency just shown by the Indian legislature to incorporate such provisions again and again in criminal legislations. And the latter to be noted, because it is counter to the constitutional values which has been envisaged by the Supreme Court. And very stringent actions are being taken by the Supreme Court when the police actions led to the death of the persons who have been arrested and kept in custody. Gauri Shankar Sharma versus State is case wherein the police officers who are being responsible for the death of the person has been convicted, and even to the Supreme Court where it has been confirmed that that such types of officials need to be very sternly being dealt with under the legal scheme. And there are occasions for the courts to examine the partisan investigations, which has also been decried through its own decision. Dilawar Hussain versus State, 1990, Supreme Court decision is one such example wherein it has been laid down that partisan investigation is something which is to be decried. So, the working of the criminal justice system at the investigatory stage of the process is concerned. And granting of bail, another area where the liberty is more involved. The question of police remand, etc., are also being subject matter of disputes and being settlement by the Supreme Court in various occasions. We are all familiar with the scheme of constitution. Most cardinal principle is contained in Article 21, which guarantees that life and personal liberty could be intact only in cases where the procedure has been established by a legal framework, and if a necessity is there to take away either life or a personal liberty, it shall be made only in accordance with the procedure which is provided in a valid legislation. And the interpretation which is being given to this term in Maneka Gandhi is well known, because it insisted that fair, just and reasonable process, which has been essential to see that the constitutional guarantee is really being kept intact. A welcome interpretation which has been given by overruling the decision which they took in K. Gopalan decades back. It took away the effectiveness of 21 against the legislative process as such is concerned. And up to this point, we have been getting only the shield against the administrative action, not against legislative action. That lacuna has now been filled because of the Maneka's decision, where I said that any process should be fair, just and reasonable, and there is room for the judiciary to intervene in such matters. Article 20 again, which is a repetition of ideas which are examined in the international context, which is contained the prohibition against ex post facto law, nala poine sine lage and nala crimen sine lage, which has been contained in this, and prohibition against double jeopardy, prohibition against self-incrimination. These are examples in constitutional scheme, which has been concerned about the criminal process and hence the possibility of arbitrarily denying the rights of persons are concerned. And the minimum guarantees are being envisaged by the constitutional scheme. It is under this scheme again the statutory provision has to be interpreted and understood by the legal framework is concerned. And Article 22 again envisages the rights which has to be guaranteed for a person who is being subjected to arrest. The grounds of arrest should be communicated, and the right to consent and to be defended by a lawyer of his choice, and producing before a magistrate within 24 hours of arrest, so that legality of the question of the arrest and detention could be examined by an independent impartial tribunal, which of course we already seen that is a requirement of the international human rights norms also. Equality, which guarantees or prohibits discriminatory criminalization, differential administration of criminal justice, different punishment for the same offense, entitlement of equal justice and free legal aid are the dimensions of interpretation of the clause which guarantees equality before law and equal protection of the laws. Power of arrest, which is the most important power in the hands of police, by of course generally by the police, otherwise individuals could also resort to arrest. But we are concerned about how the police could exercise this power. And you can see this has been subject matter of examination by the apex court. Joginder Kumar versus State of UP, 1994, and D.K. Basu versus State of West Bengal in 1997, which very been shows the importance which is attached to this power and the need to regulate the power which has been granted to the executive and see that the valuable rights of devotee is not being arbitrarily being denied. So it resulted in guidelines for police. Subsequently, of course, it has become part of the statutory scheme. So it supplemented things which has not been expressly mentioned in CRPC and said that this is forming part of the integral part of the just and fair process, which of course has been accepted by the subsequent enactments which incorporate many of the suggestions which came from the Supreme Court. It's also an illustration of how the judicialization of the constitutionalization of the process has given the wider possibility for the judges to give wider meaning and give protection for the rights in a different manner than which has been otherwise been possible under the statutory schemes. And it has also been given directions to the police and magistracy that these guarantees which is there for an arrested person shall be intimated to him that you are having such and such powers which has been given by the court, so that otherwise an ordinary person may not be able to have a comprehension of what are the rights which he is having. So that it becomes made more possible. And also the most important observation which is made by this Joginder Kumar and D.K. Basu is that merely because you do have the power granted by the law to arrest a person does not mean that you should do or exercise that power whenever there is an opportunity to make use of it. The existence of power of arrest is one thing and the exercise thereof in another, in the sense that you need not always exercise it. You use it sparingly where it's inevitable, and if possible to avoid an arrested person, it's better to avoid it because it will also be bringing much more, what we may say, the lowering the status of the person in society. When a fellow is seen to have been arrested by the police, normally there will be a prejudice against that fellow, thinking generally by the public that he has done something grave offences. So the humiliating the person by the exercise this power is also to be avoided. That's why there is existence of power and exercise thereof are two different things. If we can give a notice and ask him to appear before the concerned officials, and they will be able to do it, why should you deprive him his liberty? Let him continue to be in as a free person. And this way in which the humanization, the process of administration of criminal justice is being done through the intervention of the Supreme Court. Legal aid assistance, which has been part of the directive principle of state policy, which as part of it has been accepted as part of the procedural law, now been interpreted widely and mandated that legal aid at the expense of the state becomes mandatory in cases where the person is incapable of affording to pay for a lawyer to defend himself. And this trend has been shown in various decisions, starting from Husainara Khatun, Khatri to M.H. Haskot, probably the first in this series, Sheila Barse, Sukdas, Mohammed Hussain. Many good number of cases are there where this issue has been addressed, and it's now established that trial without the assistance of a lawyer because of the inability of the accused person to pay, if that process is going to end in denial of his liberty, incarceration of the person concerned, it is becomes a duty of the state and the magistrate to inform that there is such a right which exists and to arrange a lawyer of competence to defend that fellow so that the trial process is concerned. And obviously the Article 32 and 236 most important provisions in the constitutional scheme, which gives you 32 specifically when fundamental rights are guaranteed, and says the following are your rights which has been there in Constitution. Any right without a remedy will remain in the textbook, not having any practical implication. That's what we see in many nations where they have been operating their rights but fail to provide for any process through which you can get it enforced. Probably we are in a fortunate position that Constitution provides for a right to remedy where you can move the apex court itself. We have already seen in international human rights dimension that there will be a right to challenge the legal process which demands your liberty, approach the judge or the judicial system to examine the legality of the actions which have been taken. And this is being envisaged in Indian Constitution 32 as a fundamental rights and 226 as a otherwise right which could be exercised by the high courts. So that they are in a much more better position when compared to the enforcement of the rights are concerned. And another developments which application of the human rights standards in seeing the penalty part, especially in the context of the penalty. We do have a good number of cases which comes in, starting from 1973, where Jagmohan Singh, where the Supreme Court said that is perfectly constitutional to impose capital punishment, and there is nothing which could be examined in the context of the Constitution. But subsequently, within another 7 years, Bachan Singh came before the Supreme Court. We know that the Supreme Court has been called upon again to examine the legality, the constitutionality of imposition of penalty in India is concerned. It is post-Managa decision because we know that in 77, Supreme Court came out with a new interpretation of the procedure established by law contained in Article 21. making it should be fair, just and reasonable. So when the imposition of capital, whether it is a fair, is a just or a reasonable exercise of the legislative power, if not, why can't it be struck down? Such a possibility of raising it again came, and that's why exactly the question has been raised in Bachchan Singh within a short span of time. And the Supreme Court re-examined the issues, but they find that it's perfectly within the constitutional framework. There is nothing wrong in the imposition of capital punishment. And think that is reasonable by examining the process through which the capital punishment is being awarded. They said that this has been awarded only in a rarest of rare instances. Not in all cases they are resorted to, because there has always been an alternate punishment which is available. Either you can go for a capital life imprisonment, or you can insist for a capital punishment. So when an alternate availability is there, so there is a judge who is been appreciating the whole situation. He is a judge who is senior enough in the judicial cadres. None other than the session judge is examining. He applies his mind. There is a pre-sentence hearing which already seen in Chandra Singh, which has been made mandatory. It is already been there in the statute books. It is not without hearing that is being done. So it is also possible to take the pre-sentence hearing in detail. There are the mechanisms to appreciate fully. Then they decide whether the capital punishment is to be given or not. And that process, they said, is fair process. And this is availability of alternate punishment. And that is exactly the basis in which the single punishment which is prescribed has been challenged in Mitu, the state of Punjab, 1983 decision. But they said that applying the ratio of Bachchan Singh, where the possibility of an alternate punishment makes the process fair, and the other procedure formality which judges could adopt to see that all materials which are necessary for a fair decision is brought before them, makes it fair, then the non-availability of the alternate punishment makes it obviously out of the fairness which is concept which is being developed in Bachchan Singh. So it is this ratio which makes it automatically to be annulled, because there is no other way. When you apply the ratio of the Bachchan Singh, this has to be, that is a mandatory death penalty provided has to be annulled by the Supreme Court, and they did it. There is in context where I said that irrespective of this annulment and unconstitutionality of a single punishment, single death penalty without an alternate, being declared as unconstitutional, unfortunately Indian legislature repeatedly incorporating solitary mandatory death penalty in some of the legislation which is subsequently made after Mitu's decision also. That is something which we should be aware. The other dimension of application of the human rights dimensions and possibility of avoidance of the capital punishment, if possible, is the power which has been exercised by Indian Supreme Court to examine the constitutionality of delayed execution of death penalty which has already been awarded and confirmed by the highest authorities in the judicial system. TV Vadisharan versus the state of Tamil Nadu, 1983, we try to quantify the delay. Again, which has been addressed in Shah Singh, where there is a difference of opinion which is expressed, whether it is a particular period of time or it can be varied. And again, that has been pointed out in Javed Ahmad, finally resulting in Triveni Ben versus State of Gujarat, clarifying the position wherein the delay is a crucial factor in re-examining the possibility of retaining the capital punishment. And in many cases they say that unexplainable, unreasonable delay in execution of sentence which has already become final is a matter of concern, and the agony which has been undergone by the person who has been languishing in jail awaiting the execution is something very crucial. So it makes it's possible for the court to commute the sentence going to the life imprisonment. And of course, this is not quantifying the period. They say give it to the authorities to decide, from case to case to decide what type of delay, which is very crucial in determining. But they say accepted that there is a residual power left with the judges again to intervene when the all judicial process is over, to see that the fairness is still being continuing to be administered in case of persons who have been put in condemned cells also. And the manner of execution of the death penalty is also being subject to examination by the Supreme Court. In Dina versus Union of India, a case which decided in 1983, where they said that hanging as a method of execution of the capital punishment is constitutionally valid. But at the same time, in another occasion where the Supreme Court was called upon to decide the legality and acceptability of an order issued by the High Court for public hanging of an accused person, which was examined in Attorney General of India versus Lakshman Devi, 1985 decision. The court said that it's so barbaric that such a practice is not to be accepted in Indian context, because it will be so arbitrary and iniquitous to resort to such way of execution is concerned, and said that it is not possible to accept that the order to hang a person publicly so that deterrence will be there, where people will be deterred from committing crimes. Such an attempt has never been accepted by Indian judiciary. Another area of substantive criminal law which came for the examination of the court is the attempt to commit suicide. Good number of cases which came before the Supreme Court, and various high courts also examined in occasionally. Amity, Sripati, Dubal versus State of Maharashtra, R versus P. Ratnam versus Union of India, Gyan Kaur versus State of Punjab, with after a controversy and difference of opinion within the Supreme Court, finally they said that it's unconstitutional, unfair to put a person in trial again for the miseries which he has been undergone already, which resulted in a failed attempt to commit suicide. And inside that level, it's decriminalized in certain extent that a person of adult age who is being failing to commit suicide, attempt to commit suicide, there should be no criminalization as it is concerned. And there is an example from Kerala High Court, C.A. Thomas Master versus Union of India, who came to the Supreme Court, High Court of Kerala to give permission for him to end his life. That is constitutionally guaranteed right is concerned, which has not been accepted by the High Court, and he has not been given any remedy, though he has repeatedly been knocking at the doors of the High Court of Kerala in many occasions. And the fact that he commits suicide later is a different issue. Homosexuality is another area where the constitutional intersection of the constitution with the substantive criminal or criminalization process is being examined. Starting from the NAS Foundation versus NCT Delhi, decided in 2009, where it did appeal in Suresh Kumar Kausal in 2004 decision of the Supreme Court, where the Supreme Court found that it's quite okay to have such a provision which penalizes the homosexuality, section 377 of the IPC. But later we can see some other cases where it came before the Supreme Court, National Legal Service Authority of India, where Justice Radhakrishnan was considering the constitutional identity of Hijras and the community system has been accepted and been based on Article 21. So again, we are getting a hope that the Supreme Court is opening its doors for examination of the issues further. And Puttaswamy decision 2017, which opened up the need for protection of the privacy as a constitutionally guaranteed right to choices under Article 21. It's really been paved the way for the examination of the issue of homosexuality again by the Supreme Court, which came in nowadays Singh versus Union of India, a 2018 decision where it ended in decriminalization of homosexuality. And that's a journey of acceptance, or rather the constitutional validity of the substantive criminal lies being examined in some context. Joseph Shine versus Union of India, where the provisions in penal code relating to adultery being examined in the constitutional validity of its being examined by the court, and finally said that it is unconstitutional. And there are other number of cases which could be examined in this context, wherein it talks about the constitutionality, because the constitutionality of substantive criminal law could always be possible to be examined. But there is not much examples which can be shown. But theoretically, when you say that the right is being protected and the regulation is possible on the guaranteed or being provided grounds in the Constitution itself, that too by a reasonable measures, so there can be possibility of legislation which cannot be satisfying the reasonableness standard which has been adopted in the Constitution. So the criminalization process is could always be subjected to examination in the light of the constitutional provisions. But that has been an area which has been not that fruitfully been made use of. Not only in India, even in US you can see that these issues are not being seriously being dealt with. And if they do it, they very respectively did that job. And at that level, the possibility of that examination, so it is open, is not being fully utilized by the judiciary, not only in India but also in USA. But I don't know whether that stand will simply continue to be so. But it's a different version. And there are also instances wherein the Supreme Court examined the need for police reform and need for also continuous observation of the legality of actions of the investigating agencies. Vidi Narayan versus Union of India. Prakash Singh is another decision wherein the Supreme Court was trying to discipline the police, trying to see that the police is being reformed in many respects, made a fruitful agency for maintenance of law and order, and not an agency for always being in conflict with the human rights and the exercise of the power by the authorities are concerned. And another area which has been developed by Indian Supreme Court is the development of the public law remedies, which I already mentioned earlier in context of referring to the Nilabadi Bahra. It started with Rudul Shah versus State of Bihar, where a person has been in jail for a long period of time without being examined why he is in jail, which court, what case is pending, which court is really handling. Then nothing is done, but only the fact that this fellow remains. And it came to know light later that he has been arrested for some petty cases, been remanded in custody, and his case has already been acquitted long back. And nobody made these developments, and this fellow was languishing. What should be the remedy? Because already damage has already been done. More than a decade he has been in jail. And court said that at least we can compensate him by giving him money. Monetary compensation, there is no other way which has been available for the court. And this has been examined in many cases, adopted in many cases, and compensation has been awarded for the violation of fundamental rights in many contexts, starting from Rudul Shah. And a large number of cases are there which we can enumerate. And these are the developments which really taken place or as Indian legal framework is concerned, vis-a-vis the constitutional background and the examination of judicial process, or bringing the process within the four walls of the criminal law. Rudul Shah, Nilabadi, Bahra, Kasturilal, we already mentioned earlier, which has been a case where the person has been and fled to Pakistan, was also doing a sovereign function so that he can get no remedy to get it compensated by approaching the court of law is concerned. Something which is so unfortunate that now as it stands we are progress further and they are not leaving him without any remedy, because at least the Nilabadi Bara made it possible and clear that no play of sovereign immunity can be raised when the court is examining the possibility of protecting the fundamental rights, or in instance of violation of fundamental rights are being adjudicated. Nobody can come to the court and plead that we were exercising the sovereign's function. Nothing doing. That is not the way in which the courts are going to entertain such types of pleas. And there is also a welcome development so far as the Indian judicial system is concerned. I think this will be the bird's eye view of this. Requires much more deeper. It's also an area which we could go for a much more comparative analysis of development which takes place elsewhere, especially in context of USA. But it requires much more time, which I could not take now because of the need to wind up the discourse within an hour, which I hope that I am nearing, and the 4 minutes are left. So I place it before you. I am not claiming that anything unknown to you all being presented, because all known to all of us. But it's only an attempt to summarize and have an overview of how these developments are taking place in India is concerned. That's all what I claim. Thank you. Thank you for giving the opportunity and inviting me to be part of this process. Thank you again for the same. Thank you for this coming and being with it. It's we who are the accused. It's you and me at any point of time can be an accused person. So don't have the feeling that accused somebody is right. Accused is anyone who has been caught by the criminal law, rightly or wrongly. And rightly they have to establish later by their effort of investigation and collecting evidence. So I don't think that this humiliation can be justified in any manner as a part of the investigation process. Naturally, we have to invoke the protection which is afforded by constitutional scheme. The privacy, for example, can be a shield, whereas we can ward off the possibility of a person being humiliated for the purpose of that. There is no positive contribution is going to come from this exercise by the police or any other authority who is exercising such a power. This is my reaction.
Thank you, sir, for the answer. The second question is that how the privacy can be protected in the era of AI, as IT Act is not much clear on the new technologies, crime through AI.
I have no answer. We are all facing the difficulty of getting ourselves screened. The moment you go out of your house, inside also, I don't think that you are being protected. The moment you use the internet, the moment you go for a search, you are being bombarded with information which you don't want. Many people come, if you want to have a car to be purchased and you just search what is the price of the car in the market, in the current market, then all the car agencies will come to you with their suggestions and your mobile will be flooded. This is the way it has been Now been there, I don't know how to prevent it happening. I don't think that I can avoid the possibility of being in the network because that becomes impossible. Now we came to know each other and communicate each other because of the plus points of the network which has been available. And the other point is that everyone is included into your life. When you go out, there are CCTV. Wherever you go, there is CCTV. And whenever you suggest, next day when you get into that, what suggestions come to these things you want to buy. Whether you want to buy this book or that book, last time you made this book and this is closely associated. And otherwise they will say, those who bought this book also bought these books also. Please take this away, which intrusion into all your personal inclination matters all always been coming. I don't think that there is an easy way out from this. Probably the data collected and make use of it. There can be some regulation that is, of course, in current scenario, we are trying for that to see that the data so collected is not being used for any purpose which you are not being considering. I don't know how far it would be. But it can also be a matter of criminal, I don't know. Whether in the process of procedural aspect, sometimes it may also come in as matter of criminal, also identification for many other things which comes in. Where you may be able to challenge the acceptability of some evidence which comes into identify cases. Hard pressed for us, public interest to have a fruitful investigation. Vis-a-vis the protection of rights of person has been tampered. Is already been made by the Constitution vis-a-vis the procedural law which is already having. How to balance in a particular case, we say it's a question of fact. There is no general principles can be laid down. Based on the factual situation of each and every case, necessarily judiciary has to balance this power. But whether our judiciary do have sufficient time to do that, that's a different issue. Because normally these issues are arising in the context, in the magistrate courts, the lowest functionary in the criminal justice administration, which has been flooded with cases, hard pressed for time, and they not be able to appreciate each and every case in the way in which is supposed to be appreciated. So when they are being hard,
it has been really a treat to our knowledge and to our understanding of criminal law, coming it straight from you. And it has been so long that I have heard you on your academic deliberation on the criminal law side. Your lecture was really true insight into the international aspects of criminal procedure. Number of cases you have cited, we have taken notes of it. And I again thank you, sir. Thank you so much.
Thank you. Okay, thank you.
Okay. Sir. Thank you. Now we also have Professor Sharon Gupta sir with us. Welcome, sir.
Moving forward, the next session focuses on constitutional vision of access to justice in India, reflection on contemporary issues and challenges.
To take us through this thought-provoking discussion, we have with us Professor Dr. Shailendra Kumar Gupta. Dr. Shailendra Kumar Gupta is a professor of law at Banaras Hindu University, Varanasi, with a PhD in environmental justice. He is the president of Academic Discussion Group, and he has worked as the executive director of Legal Aid and Service Claim.
Without further ado, let us welcome Professor Dr. Shailendra Kumar Gupta sir for this lecture. Over to you, sir.
Am I audible?
Yes, sir.
You're audible, sir.
So, very good afternoon to learned organization of this program. My dear fellow participants and everyone who is listening to me in this afternoon, I welcome you all in this session. I would like to start my lecture. I have prepared certain PPTs with the help of my fellow research students. I seek your permission to go through with the help of my PPTs. Please run that PPT.
Yes, sir. Please visit the
Just,
PPT.
just I need 1 minute. Uh, okay. Okay. So can you see my PPT?
Yes, sir. It is visible.
Yeah, yeah, yeah. From your side, the voice is so low, so I'm not able to hear you properly. Okay, anyway.
Yes,
So,
sir. It is visible, sir.
okay, okay. So, my dear students, I'm sorry, my dear fellow participants. So, I have chosen this title, that is the Constitutional Vision of Access to Justice in India, Reflections on Contemporary Issues and Challenges. Friend, when we have completed 75 years of the Constitution of India, it was adopted on 26 November 1949 and it was fully operated on 26 January 1950. Around 300 learned persons, great freedom fighters, great jurists, lawyers, national leaders participated as the members of the Constituent Assembly. And they done a lot of research work. They have done a lot of studies and they deliberated continuously for about 3 years. I'm referring the Constituent Assembly debate that runs around 10,000 pages, and that is freely available on the internet. So, friend, if we see our Constitution, the Constitution starts from our preamble. Friend, preamble must be taken very seriously because every student of law has been taught about the importance of preamble and the constitutional law of India. Friend, first of all, being a student of constitutional law, let me say something about the importance of constitutional law, constitution, and constitutional vision. Because I cannot proceed further unless I refer to what is the constitutional law and what is constitutional vision. Then I will come on the preamble of the Constitution of India. Friend, perhaps I'm aware that most of you must be appreciating the difference between having a constitutional law and having a constitution. In other words, a country may have a constitution, but it may not have constitutional law. So what is the difference between having a constitutional law and constitution? A country may have a constitution. There are 200 countries right now. And I believe that except few, around more than 190 countries of the world, they must have a constitution. And India is one of them. India is one of them. The Saudi Arabia may have a constitution, Israel may have a constitution, Palestine may have a constitution, North Korea may have a constitution. Somalia may have a constitution. China may have a constitution. Pakistan may have a constitution. The Germany had a constitution during the World War II. Italy had the constitution. Japan had a constitution at the time of Second World War. So many autocratic countries, so many dictators, arbitrary regime, authoritarian regimes, they have a constitution. So merely having a constitution is not suffice. The constitution may be arbitrary. The constitution may be highly arbitrary. During the Second World War, Italy and Germany, they had a constitution. They had made a law. Highly arbitrary laws were made. Discriminatory laws were made. Anti-human rights laws were made. Unequal laws were made. Unjust laws were made. And therefore, friend, as a student of law, I argue that having a constitutional law is different and having a constitution is different. A constitution of a country may not be as per the spirit of the constitutional law. This is my thesis. So therefore, friend, the question is, what is constitutional law or what is constitutionalism? So my point is that having a constitutionalism in a country is different thing and having a written constitution is a different thing. So what is the difference between the having a constitutionalism and having a constitution? Friend, if we see the gradual development of the constitutionalism, when I say constitutionalism, it includes justice, fundamental rights, the spirit of federalism, respect for human rights, limited power of the government, superiority of the constitution, written form of the constitution, limited power of the amendment, independent judiciary, power of judicial review, local self-government, and so on. Therefore, friend, the constitutional lawyers have identified certain basic structural principles relating to constitutionalism. So constitutionalism envisages that there must be a written constitution and constitution must be supreme. There must be, the constitution must be informed by the spirit of justice. I will be talking about how the concept of justice has been conceived under the Constitution of India. The constitutional law presumes the existence robust scheme of fundamental rights. It presupposes some sort of federalism. Federalism here does not mean merely the division of power between center and state. No. Federalism is a culture. It is a concept. It is a concept which provides decentralization of power. It is a concept which provides autonomy of the people. There may be a country which consists of different kinds of people. They have the different culture, language, religion, lifestyle, food habits, and so on. Their languages may be different, their religion may be different, their culture may be different, their local aspirations may be different. So the New Delhi must respect the feelings and autonomy and spirit and cultural aspirations of all the states in India. There should not be hegemony of a one dominant community or one culture. So federalism is not limited as we understand. Federalism means when we respect the autonomy of people, their local aspiration, their cultural, religious, geographical diversity, which is more inclusive. That is federalism. Often in India, we identify the federalism just merely by distribution of power between union and state. I humbly disagree. The federalism should not be confined to merely separation of power between union and state. But federalism also demands that there should be separation of power within the state. I'm talking about the empowering of local self-government, 73rd and 74th Constitutional Amendment. I'm talking about the importance of local self-government bodies like municipal corporations and gram panchayats. I'm talking about that. Federalism means empowering the local self-government like municipal corporations and gram panchayats also. So federalism should not be confined to the traditional division between power between union and state. No. And therefore, federalism is a concept. It is a progressive concept respecting the diversity, respecting the multiculturalism, respecting the local aspirations. That is the federalism. So friend, I was talking about supremacy of the Constitution. The supremacy of the Constitution cannot be established and cannot be preserved unless we have a written Constitution. No Constitution can be considered a modern and progressive unless it is informed with the spirit of justice. Justice is the goal of law. Justice is the very soul of law. So when we talk about the constitutional vision of India, the constitutional vision of India cannot be conceived without the constitutional understanding of justice. So preamble refers the justice, and three kinds of justice has been referred: justice, social, economic, and political. No constitutional law will be conceived without a robust scheme of fundamental rights. You may call it human rights also, because conceptually there is very thin difference between the concept of human right and fundamental rights. Our Honorable Supreme Court has rightly pointed out many times that the fundamental scheme of fundamental rights under the Constitution of India represents a robust scheme of human rights as well. So for the purposes of fundamental right chapter, that is the part 3rd of the Constitution of India, the Supreme Court has never made a technical difference between the fundamental rights and human rights. When Supreme Court has interpreted particularly Article 21 and Article 32 and 226, the Supreme Court has been very clear, and rightly so, that fundamental rights also represents the fundamental human rights. So friend, what I'm arguing is that the no constitutional law can be considered a progressive law unless we have a progressive and robust scheme of human rights and fundamental rights. So friend, what I'm talking about is that the Constitution of India, in our country, there is a constitutionalism. Constitutionalism also presupposes the existence of supremacy of the Constitution, supremacy of fair judicial system. No constitutional law can be considered modern and progressive unless it has an independent judiciary. Because in every country there will be constitutional disputes, there will be legal disputes, there will be litigations, there will be disputes between center and states, there will be disputes within the state, there will be disputes between the government and the people of that country, there will be intergovernmental disputes, there will be variety of disputes. So we must have a robust scheme of dispute settlement mechanism that is known as the judicial system. Fortunately, we have in our Constitution of India, we are very lucky to have an independent judicial system. We have the constitutional courts of Supreme Court and High Court. We have the independence of judiciary. We are so lucky. And if we have the judiciary, if we want that fundamental rights must be enforced effectively, if we want that the parliament or law-making bodies should not legislate in an arbitrary manner, if we wish that the parliament and state legislatures must legislate on the basis of spirit of the Constitution, and they should not violate the fundamental freedoms of we the people of India, then we must have a robust scheme of judicial review. So we are very fortunate that we have a robust scheme of judicial review under Article 13 of the Constitution of India. So Article 13 clearly says that a state cannot make any law that can violate any of the fundamental rights that has been given under Part 3rd of the Constitution of India. Friend, I would like to draw your kind attention on the term any of the fundamental right. So sometimes I teach in my classroom that the no parliament in India can make a law that should violate even 5% of the fundamental rights. No, even 1% violation is not permissible under Article 13. Otherwise, there would have been some exception. Article 13 does not provide any exception. It means even 1% violation of any of the fundamental right is not possible under Article 13. And if any state, and friend, please, I would like to draw your kind attention on the term state that has been defined under Article 12 of the Constitution of India. So state must be taken in a broader sense. The state does not merely include parliament and state legislature, but state includes the central executive, that is the central government, and state executive, that is the state government. It also includes the local authorities and other authorities created under the Constitution or any law. So The hundreds of the cases have been decided on interpreting and giving the broader definition of a state. So friend, in the light of Article 12, that is the broader concept of a state, and what I want to say is that a state cannot make any law that can violate even any part of the fundamental right. And if a state makes such a law, then Supreme Court is there under Article 32. Any person can approach the Supreme Court. Any person can approach the High Court under Article 32. And High Court and Supreme Court both have a constitutional right and jurisdiction under Article 226 and 32 of the Constitution of India to invalidate any executive order or any law. And my dear friends, the law includes the constitutional amendment also. Even the constitutional amendment which has been made under Article 68 of the Constitution of India cannot be allowed to violate our fundamental right. That is the decision of the Keshwan Bharti case, the basic structure doctrine. So friend, what I'm talking about is that I'm trying to say what is the constitutional law. So what is constitutionalism? So constitutionalism, let me once again summarize. What is the constitutionalism? The constitutionalism includes certain modern and progressive fundamental principles of governance, and it includes the supremacy of the constitution, a written constitution, a robust scheme of fundamental right, independent judiciary, limited power of the government, and limited power to amend the constitution, and doctrine of judicial review, and federalism, and so on. So these are the certain modern and progressive principles of constitutionalism or constitutional law. Now friend, having said so, now I would seek your kind permission to say and to interpret these principles in the light of the Constitution of India. I'm so proud to say that, and I'm so happy to say that all the principles, all the modern principles and progressive principles of constitutionalism have been adopted in letter and spirit in our great Constitution. I'm so happy to say that. I'm so proud of our Constituent Assembly. I'm so proud of each members of the Constituent Assembly who provided us a modern and progressive and inclusive Constitution of India after a thorough discussion that went up to the 3 years. We were not there at that time, but we can read the Constituent Assembly debate even today. And friend, the Constitution of India, perhaps it has been said that, I do not know, but most of the books of the constitutional law have written that the Indian Constitution is perhaps one of the largest constitution in the world. Everything has been made so clear. That's why everything has been elaborated. It has been written in detail. There should not be any doubt of undue interpretation. That's why everything should be written in black and white. Detailed provisions have been written. And that's why, and India is such a big country, having so many religion, culture, language, diversity, geographical diversity, cultural diversity, such a big country, such a large number of people, having a great civilization, having a great history, and having the legacy of colonialism. a painful part in our history. And that's why the Constituent Assembly members and our Constituent Assembly took 3 years to frame a constitution that should be modern and progressive. And I would like to repeat that Indian constitution is a modern constitution, it is a progressive constitution, and all the modern and progressive features of constitutionalism can be traced in terms of the provisions of the Constitution of India. And friend, I seek your kind permission just to refer the preamble of the Constitution of India. The Constitution of India, if you see the preamble, we the people of India, we aspire to make India as a democratic republic, secular, socialist country. We have promised to our people that we will provide justice, and three kinds of justice have been specifically mentioned in the preamble of the Constitution of India. That is justice, social, economic, and political. Of course, after 75 years of the Constitution of India, the Constitution needs some, I agree, the Constitution of India needs some further changes, some modifications, some insertion. Unnecessarily parts may be deleted and certain new things may be added. Of course, I will agree that two more justice may be added in the preamble in addition to the social justice, political justice, and economic justice. Friend, I agree that the gender justice has become more important nowadays. So the gender justice term may be added in the preamble. I agree that in the contemporary problem of environmentalism, when India and globe is facing the environmental challenges and environmental crisis, and when the concept of environmental justice has become a buzzword, I agree that the environmental justice may also be included in the preamble of the Constitution. Because constitutional law, it is a supreme law of the land. But friend, let me repeat, as you know, that law must be living, as Professor Ehrlich has said. The law must be living. The law cannot be archaic. The law cannot be too old. The law must be living. And if law has to be the living, the Constitution of India cannot be exception to that. The Constitution of India must be a living document. It must conform to the new aspirations of the people of India. And that's why when we are facing the problems of gender justice, when the people of India are facing the environmental crisis, despite of so many legislations on protection of environment, and despite of the 100 landmark judgments of the High Court and Supreme Court, when in India we are facing the environmental crisis, when the Yamuna in the capital city of India has become a sewerage, almost a sewerage. Just I visited New Delhi 2 days back. I spent 2 days there. I saw with my own eyes the plight of Yamuna. I saw that there was no river. I found that there was a sewerage, a big sewerage. All the whole water was looking blackish. The foul smell was coming. It was almost a sewage. Where is the Yamuna in capital city of India? When almost all the rivers have become so dirty, when the capital city of Delhi has has acquired an infamous name that it is one of the most polluted capital cities in the world. So when we have acquired such an infamous tax, so when we are facing this environmental crisis, why not? And when the people of India are still unaware about their constitutional duty for protection of natural environment, when the environmental law are still not taken very seriously, when the most of the judgments of the Supreme Court, they are not being implemented in letter and spirit, when the executive is unconcerned about the protection of environment, when environment is in crisis in India, and when the Honorable Supreme Court went back in 1985 in rural litigation and entitlement case that is known as the Dehradun quarrying case. So when the apex court has unequivocally held that the right to clean environment is a fundamental right, when Honorable Justice Kuldeep Singh in Vellore judgment in 1996 have held that the sustainable development is the part of the constitutional law of India, and when he declared that the polluter pays principle and precautionary principle shall be the part of the sustainable development, when the Supreme Court has delivered landmark judgments for protection of environment, and despite of all these things, despite of a dozen legislations on environment, despite of the Ministry of Environment, despite of all these judgments, why our rivers are dying? Why there is an environmental crisis? And when through 1976 constitutional amendment in 1976, Article 48A was added as part of the directive principles of state policy, and when every citizen has a fundamental duty to protect the environment under Article 51AG of the Constitution of India. So when the Constitution of India have a specific provision for the protection of environment, then why, my argument is that, why the environment is not being taken seriously? And if environment is not being taken seriously, despite of all these things, so is not there a fair argument that the goal of environmental justice must be clearly mentioned in the preamble of the Constitution of India? And that's why I humbly disagree with the ongoing debate from last couple of years that the Constitution of India should not be amended. No, being a student of Constitution of India, I agree that the Constitution of India should be amended as and when there is a need. So I argue that in the preamble of the Constitution of India, in addition to the social, economic and political justice, the concept of gender justice and concept of environmental justice must also be included forthwith. And therefore, if there is a need for constitutional amendment, it must be done forthwith. Because the Constitution of India is a sacrosanct document, but it must be a living document. And that's why around 105 constitutional amendment has been made. So if one or two more constitutional amendment will be made for achieving the current aspirations of the people of India, the heaven will not fall. And that's why I disagree with some of the argument that Constitution should not be amended. No, the Constitution should be amended if there is a need to make it more clear and more visible and more progressive and more modern. So friend, what I'm talking about, I was referring the preamble of the Constitution of India. So Constitution of India talks about the concept of justice. and friend, all the students of the constitutional law, including my fellow participants, because all my fellow participants who are listening in this session to me, they will agree with me that the justice is the goal of law. Justice is the goal of law. And if the justice is the goal of law, the constitutional scheme of justice must be taken in seriously when I'm talking about the constitutional vision of access to justice. So first of all, we must make our vision very clear that what is the constitutional vision of justice. And that's why I'm arguing that the concept of gender justice and concept of environmental justice at least should also be added in the preamble of the Constitution. This is my humble submission today. A friend, the preamble of the Constitution of India also talks about a robust concept of fundamental right. And fundamental right includes equality, equality, freedom, and right to life and personal liberty and constitutional remedy and so many other fundamental rights, including right to religious freedom. And I'm so happy to say that we have a robust scheme of fundamental rights. So right from Article 14 to 32, so many precious fundamental rights have been given. But of course, I will agree with most of you that this robust scheme of fundamental rights have not been so effective. I agree. But so far the theoretically speaking is concerned, we have a robust scheme of fundamental rights. The preamble talks about the principle of fraternity. Often we the students of constitutional law, we do not understand the importance of fraternity. That is the brotherhood. The fraternity demands respect for dignity of each individual. Honorable Supreme Court in Menka Gandhi case in way back 1978 has rightly pointed out that right to life does not mean existence of animal right, existence of animal law, animal life. Even animals should have, I will argue that even animals have a right to dignity. Even the animals have right to survival. Even animals have right to life. We should not treat even animals unfairly. And that's why we have the Wildlife Protection Act. So the Supreme Court has rightly pointed out that the human being should be, the life of the human being and their dignity must be taken more seriously. I agree. So friend, the preamble of the Constitution of India talks about value of fraternity, brotherhood. And I'm so happy that our Prime Minister in recently concluded G20 summit has given a call for Vasudhaiva Kutumbakam. I'm so happy for that. I'm so proud for that. Being an Indian, I'm so proud that India has given a call for Vasudhaiva Kutumbakam. For India, the whole world is a family. Because we believe in Advaita Darshan, a great philosophy. The very soul of our history, our culture, our value, our Advaita Darshan, our Vedantic philosophy is based on integral humanism. We don't see any difference among the people. We don't want any discrimination on the basis of sex, color, religion, gender, and race. And that's why I'm so happy to listen this call that India stands for Vasudhaiva Kutumbakam. I'm so happy for that, because this slogan of Vasudhaiva Kutumbakam represent the very spirit of the preamble of the Constitution of India, which talks about and which refers for fraternity, value of fraternity. So this value of fraternity should not be confined to within the India, but it should travel beyond the India. So friend, the preamble is so important. And that's why, friend, in the preamble there is the other values also, like the unity and integrity of the country. I understand that, but today I have taken a limited topic. I want to confine my lecture only on the constitutional vision of access to justice, contemporary issues and challenges. So friend, the time is short, and that's why let me proceed quickly now. So in my PPT, I have prepared some PPT and I will improve it, and I will hand over this PPT to the Amity Law School, Rajasthan, and if they agree, they can share it with the participants. So friend, look, Professor R.W.M. Dias have identified the 5 tasks of justice. Professor Dias in his book has identified the 5 tasks of justice. And I have in my PPT, I have included all the 5 tasks of justice, and the 4th task of justice is just decision of dispute. I'm repeating, just decision of dispute. The question is whether India has a judicial system that is capable enough for just decision of disputes. Whether the people of India are getting justice, or they are merely getting orders and directions and judgments. A great judge of America once said that the American court is only the court of law, not court of justice. It means that he wanted to say that the American Supreme Court is not giving or not providing justice. It is just delivering this. It is just delivering orders. So there is a difference, friend. There is a difference between delivering the order and giving the justice. Whether justice are being done in our courts or not, whether the people are happy, whether the people are satisfied that, okay, I have got the justice, or they have got only orders. When the 5 crore cases are pending, 50 million cases are pending, when the cost of litigation is so high, when there is a huge delays in the justice delivery system, when the father is filing a case and after his death, their children are getting the orders and judgments. When a person is unable to get a judgment from the court in his lifetime, when 15 years, 20 years, 30 years our courts are taking for deciding certain cases, can we say that the Indian judiciary or Indian courts are delivering justice? They are giving the justice? I'm leaving it up to you. Of course, I'm very happy that the Constitution of India under Article 42, in addition to the sweeping jurisdiction to the Supreme Court under Article 32 and 131 and onwards, original jurisdiction, special jurisdiction, advisory jurisdiction, so many jurisdictions have been given, and rightly so. And after having given so many jurisdictions under the Constitution of India, one special article has been written, that is Article 142, that uses the term complete justice. So Supreme Court is constitutionally bound to see that whether the complete justice is being done or not. So I'm so happy about Article 142, and I'm so happy to see the interpretation of the Supreme Court. So far, Article 142 of the Constitution of India, the Supreme Court has shown the judicial activism. The Supreme Court has delivered so many judgment and orders by using this power of doing complete justice under 142 of the Constitution of India. The Indian judiciary, and particularly the High Court and Supreme Court, they are the constitutional guardian of we the people of India. When our fundamental rights have been threatened, when we do not have the access to justice, to whom we should look for? When our parliament does not fulfill our aspirations, when executive becomes so apathetic, where can we go? We can go only to the High Courts and Supreme Court under Article 226 and 32. And Supreme Court and High Courts must have the sufficient constitutional power. And that's why I'm so happy about Article 142. And I'm so happy that Supreme Court has used Article 142 in many landmark judgments. And Supreme Court has tried to provide us our goal of complete justice. I'm so happy, friend, about Article 21. Article 21 that has become a residuary source of fundamental rights. Sometimes my students ask, sir, which fundamental right is most important for you? I say it, Article 21. And I'm so happy that Supreme Court has delivered at least, Supreme Court has declared at least a dozen new fundamental rights under Article 21. So today we have the right to environment as a fundamental right. Today we have, at least theoretically, we have a fundamental right to speedy justice. Theoretically, we have the fundamental right to legal aid. Theoretically, we have right to dignity. We have right to work, right to food, and right to primary education, and so on. I'm so happy about that. I'm so happy about the constitutional interpretation and this constitutional achievement by the Supreme Court of India under Article 21. I'm so happy about that. But of course, I'm not so happy about the actual implementation and ground realities of these fundamental rights. I'm not so happy about that. I'm so happy about the theoretical achievements, but I'm not so happy about the practical implementation of these so-called fundamental rights. I'm so happy about Article 39A. That is the part of the directive principles of state policy which talks about equal justice and free legal aid. I'm so happy that the Honorable Supreme Court, in many landmark judgments, starting from 1978 Hussain Ara Khatun case and M.H. Hoscott cases, the Supreme Court has rightly held that right to legal aid is a fundamental right. I'm so happy about that. But I'm not so happy about the ground realities of the fundamental right to legal aid. I'm not so happy about that. I will share my understanding about that. Friend, I'm just with your permission, I would like to escape with certain my slides. Friend, in this slide, I have included need for importance and scope of legal aid. And these are the importance and scope of legal aid. And look, friend, particularly point 9, reduction of legal disputes, need for mediation, conciliation and arbitration and lok adalat. Some of my fellow participants must be teaching this mediation, conciliation, arbitration and lok adalat. But when we see the ground realities, there is a need for further improvement, further strengthening this mediation. Even today, the mediation, conciliation, and arbitration in India are not taken seriously. There are vested interests. There are vested interests of the people, and some of my fellow advocate community. They have vested interest, and that's why, despite of this legislation on mediation, conciliation, arbitration, it is not so effective right now. Now, friend, if you see, I was talking about the case backlog and judicial delays, and I pointed out that 50 million cases, 5 crores cases pending, even in the March 2025. If we see the number of judges, we have 21 judges per million. Per million means 10 lakhs. And the recommendation is that there should be at least the 50 judges per million. So look, even we do not, we are not following even the 50%. The recommendation is the 50 judges per million, but right now we have the 21 judges per million. So we have to travel a lot. Look, friend, these key issues and challenges. Point number 2, economic barriers and legal aid gaps. There is a high litigation cost, and I have found this data that rupees 50,000 crores rupees are lost annually in wages in India due to high cost of litigation. And friend, if you see the legal aid, particularly the NALSA, I have been the executive director of the legal aid clinic in my law college at Varanasi for 10 years. And I'm so aware about all the laws, all the legislations, rules. Every day I used to visit the website of the NALSA and SALSA. I'm aware about the 12 schemes and notifications which are available on the website of the NALSA. I'm aware about the Legal Services Authorities Act 1987. I'm aware that there is a NALSA. I'm aware that there is a SALSA. I'm aware that in every district there is a DALSA, District Legal Services Authority. I'm aware that Honorable Chief Justice of India is the ex officio chairperson. I'm aware that the second senior most judge of the Supreme Court is the ex officio executive chairperson of the NALSA. And the same is the case at the state level. The Honorable Chief Justice of the High Courts, all the High Courts are ex officio chairperson of the State Legal Services Authority. I'm aware of in each district, the district and session judge is the ex officio chairperson of the DALSA. I'm aware that in every district, one judge has been designated at the secretary DALSA. But if you see the ground realities, friend, there are the structural questions. There are so many structural questions. And I find, I'm so sorry to say that now, I'm so happy about Article 39A. I'm so happy that the right to legal aid is a fundamental right. I'm so happy that right to access of justice has been declared as a fundamental right. I'm so happy about the PIL jurisdiction. I'm so happy about the complete justice. I'm so happy about the recognition that Article 32 is one of the most important fundamental rights and has been rightly recognized by the chairperson of the drafting committee, that is the Dr. Ambedkar. I agree with Dr. Ambedkar that Article 32 is one of the most precious fundamental right. Okay, I agree. But friend, what is the ground realities? The ground reality is something different. The right to legal aid for me is like a paper tiger. It exists only in theory. It doesn't exist in practice. Where is the budget? Where is the budget for the NALSA? Where is the budget for available to SALSA? Where is the budget at the district court level? How many professors are the part of the have been included as the member of the NALSA and SALSA and DALSA? Even in Varanasi, the BHU Law School has been a very pioneering institution, but why a professor of law in Banaras Hind University has not been made an ordinary member of the District Legal Service Authority, Varanasi? Whether the District Legal Service Authority, Varanasi can think of giving the right to legal aid to the people in Varanasi and can aware the people without the help of the 500 students in my faculty and without the help of the law teachers? Why the law teachers and millions of the students are not being used effectively in the legal aid program? Why there is a disconnect? And that's why, friend, I'm so sorry to say that this right to legal aid has been remained as a distant dream. And that's why, friend. Then there are the social and cultural barriers, friend. The postmodernism says that the postmodernism highlights the importance of gender discrimination and biases. I will not go into that. Friend, look, let me say 2 minutes about this e-governance and access to justice. I'm so happy about the artificial intelligence. I'm so happy about the chat GPT. I'm so happy about the Gemini. I'm so happy about the DeepSeek. I'm so happy about the Elon Musk Group 3, Meta AI. And I see a lot of scope about the artificial intelligence in justice delivery system. But still, the use of AI in India has been a distant dream. I'm so happy that 9,000 crore rupees had been invested in the e-courts. There is a lot of things are being done. The faster paperless justice with the AI system has been conceived. I'm so happy about the National Judicial Grid, NJDC expansion 2024. And 50 million cases, but 50 million cases are still pending. I'm aware that the online dispute resolution platforms are being created. I'm aware that NALSA and SALSA and DALSA are there. I'm aware that fast track courts are there. But still, friend, I'm aware the Gram Nyayalaya legislation has been made. And I'm aware that in certain districts in Uttar Pradesh, the Gram Nyayalayas have been created. But I want to say that even today, more than 60% people are residing in the rural areas or semi-rural areas. But still, the penetration of courts are so less. Very few Gram Nyayalayas have been established in the rural areas, and that's why even today the poor and illiterate people in rural areas are struggling for getting justice, because they have to travel 50 kilometers or 100 kilometers, and they have to travel 100 kilometers for the district court, and when they come in the district court, they are not getting justice, they are getting only the dates. And even for getting a dates, they have to pay 50 rupees or 100 rupees to the peshkar. This is the ground realities. And therefore, friend, what is the recommendations? There are I have recommended certain things. There is the following recommendations. More judges should be appointed in India. There should be the faster recruitment. Friend, my students become sometimes sad. The judicial advertisement comes only in 3 years. Every year there is no advertisements. Why? Because the executive is not serious to fulfill the vacant post of the judiciary. Sometimes executive and policy makers think that fulfilling the courts and fulfilling this vacant post is a waste of money. But they forget that we need more number of judges. And therefore, friend, my second recommendation is that strengthening the legal aid program. There should be the higher funding for the legal aid institutions. Then decentralization of courts, more Gram Nyayalaya should be created. More digital infrastructure should be created. Then cultural sensitization must be taken seriously. Then holistic reform must be taken. The tool of AI must be used in the justice delivery system. Friend, since I have already said about the AI, and one of my student is doing research on the AI, that's why I have a greater understanding about the artificial intelligence. But right now, because of the shortage of time, I would not say much about this AI, and because it has its own problems. But what I can say that I see a lot of potential of using the AI in the justice delivery system, and that's why if the artificial intelligence should be used wisely at the district court level, then these 5 crore cases may be reduced substantially. This is my honest understanding. Then, friend, now what are my conclusion? Because time is very short, and that's why that's why I have jumped on my conclusion. So, following are my conclusion. My first conclusion is that the constitutional vision of justice must be taken very seriously. Justice, social, economic, and political. All three kinds of justice must be taken very seriously. India is still struggling for providing social justice, economic justice, and political justice. India is fasting so fast. Our economy is fasting so fast. Our economy has become the 5th largest economy of the world. I agree. And I will be very happy if the India by 2028 or 27 will become the 3rd largest economy of the country. I will be very happy. But I'm not happy about the existing economic divide. The rich people should not become rich and poor people should not become more poor. That's why the Constitution of India talks about the social justice and economic justice. The Supreme Court in many cases has highlighted the importance of the constitutional vision of inclusive economic growth. So the economic justice and social justice demands for more inclusive policies in every field, more inclusive economic policies, more inclusive legal policies, more inclusive political policies, and more inclusive gender policies, more inclusive child policies, more inclusive cultural policies. And that's why the 12th five-year plan titled the goal of inclusive justice. Then, friend, my second conclusion is that for realization of fundamental rights under Article 32 and 226, Article 32 and 226 should be taken more seriously. Why the people of India needs a PIL jurisdiction? Why do we need a PIL jurisdiction? And if the PIL is so important, why it should be confined only to the Supreme Court and High Court? If I'm a poor fellow, why such kind of PIL kind of platform should not be available at the district court level? This is my argument. Why I need to travel to the Delhi? Why I need to travel to the capital cities? Because there are so many large states like UP. Why I need to travel to the capital cities? Why I should not have the access to justice at the local level, at the district court level, particularly when my fundamental rights are being violated, when my fundamental freedoms are being violated, when my fundamental human rights are being violated? Why I need to travel up to the Supreme Court and High Court only? Why at the district court level, why there should not be some mechanism or some forum? And that's why if the constitution need to be amended, it must be amended. This is my humble submission, that if for effective implementation of human right, if effective implementation of fundamental right at the district court level is necessary, and for that, if the constitution demands some amendment, the Constitution of India must be amended right now. And that's why the access to justice is so important. Then, friend, my fourth conclusion is that access to justice is more important for certain vulnerable sections of the society. And when I talk about the vulnerable sections of the society, I'm referring the poor people, I'm referring the children, I'm referring the differently able people, I'm referring the women, I'm referring the marginalized communities, because they need the access to justice. The rich people and the strong people, they can get the justice from the district court, high court and Supreme Court. But these poor people, children, disabled people, women, marginalized sections, tribals, Dalits, for them, access to justice is more important. And that's why we must have the special laws and special policies and special programs and special authorities and special mechanism for affording this access to justice and speedy justice to the vulnerable sections of the society. And then, friend, my fifth conclusion is that we need to strengthen this fundamental right to legal aid. One of my PhD scholar has just submitted a PhD on prison reform, and we have read about 150 judgment and order. And I read all the orders and judgments of the Allahabad High Court in the prison related. And I found that one of a great judge has written that how the poor condition of this so-called fundamental right to legal aid. We reached to the conclusion that so far the fundamental right to legal aid to the prisoners in state of UP is concerned, it exists only on paper. There is no effective legal aid program for the prisoners in Uttar Pradesh, and it has been clearly mentioned and recorded by the Honorable Judge in many judgments in Uttar Pradesh, Allahabad High Court. And that's why, friend, I'm of the view that the legal aid as a fundamental right should not remain as a paper tiger. It should be taken seriously. As Professor Ronald Dworkin has rightly said, that right should be taken seriously. And if the right should be taken seriously, then the fundamental right and legal, including access to justice, fundamental right to access to justice, fundamental right to legal aid, the fundamental right to speedy justice, the fundamental right to affordable mechanism to get justice should be taken seriously. And then, friend, my sixth conclusion is that legal education needs to be inclusive. Today, the quality legal education is confined to only certain people. The cost of education in the National Law School and in other higher educational institutions is so high that the poor people and lower middle class family, they cannot afford that high cost of education. And if the common people will not get the quality education, then they cannot participate in the constitutional vision of providing the justice. And then, friend, my seventh conclusion is that legal education should also be in the regional languages. Right now, most of the national law schools, they are providing the legal education only in one language, that is English. And the legal education is not being provided in the regional languages. Recently, I have seen the advertisement of the Jodhpur National Law School. I'm very sorry to say today that they have clearly mentioned that. Those who do not have the a particular level of the English language, they are not supposed to apply it. They have clearly mentioned that those who are teaching in the national law school, they shall be given preference. I'm so sorry to point out that. So this colonial mindset that the education can be provided only in the English language, and it should not, why the education, legal education, why it cannot be provided in other languages, in the regional languages. And if the legal education has to be inclusive, if legal education must go to the lower middle class families and the poor people also, it must be in the regional languages. And that's why the national law schools and the private universities must think seriously. If the legal education needs to be inclusive, illegal education should be as per the social justice. They must think about changing their policies. And that's why, friend, the legal education should be as per the National Education Policy 2020, because the National Education Policy clearly encourages the education, including legal education, in all the regional languages. And that's why the legal education must be encouraged in the Tamil medium also, in the Bengali medium also, in the Marathi medium also, in the Telugu medium also, in the Hindi medium also, in the Odia medium also, because most of the students, they have been educated in the regional languages, and there should not be a digital divide or the language divide. And that's why, if I'm permitted to say that, I would like to say that in the preamble of the Constitution of India, the concept of linguistic justice should also be included in the preamble of the Constitution of India, because there is a lot of linguistic injustice which is going on in India. This is my humble submission. And then, friend, I have only 3 more conclusions. Modern technology must be used, including the AI. I have said it. My 9th conclusion is that the legal aid movements should be taken seriously. There are structural deficiencies in the Legal Services Authority Act 1987. There are structural deficiency in the composition and working of the NALSA, SALSA and DALSA, and that should be addressed. When the Chief Justice of India, when the Chief Justice of all the High Courts, when the District and Session Judge is so preoccupied, they have so many judicial work, they have so many administrative work, where is the time for them to give some time for the meeting of the legal aid and for presiding the meeting of the NALSA, SALSA or DALSA? And that's why they should not be burdened too much. Honorable Chief Justice of India, Honorable Chief Justices of all the High Courts, Honorable District Session Judge in each district should not be unnecessarily burdened. And that's why we must have a full-fledged officer or full-fledged, I would like to say that some retired judges must be made the prominent members of these authorities. Therefore, they should give their full time. The legal aid is not the part-time job. When the 5 crore cases are pending, when the cost of litigation is so high, when there is so much judicial delay, when the access of justice is a fundamental right, when fundamental right to speedy justice is fundamental right, then why these authorities should be overburdened? And that's why the retired judges of the Supreme Court and High Courts must be appointed as the full-time authority, because the legal aid cannot be treated as a part-time job. This is my argument. And that's why I'm arguing that the structural questions must be addressed. And legal aid clinics in the universities and colleges, I should not say something about that, because I myself has been the executive director of the legal aid clinic in my law school. And I have found that there are so many problems. When a teacher is working in the legal aid clinic, he should be given some concession. Why the law colleges are not giving some concession to that teacher? Why a teacher of legal aid is supposed to give extra time for the legal aid? Why there should not be some concession in terms of the teaching load? Why some financial encouragement should not be given to that teacher when he is giving more time, when he is giving more energy, when he is heading 100 students, 500 students, when he is supposed to go in the villages, when he is supposed to go for the mass literacy, when he is supposed to do the lot of social awareness, when he is supposed to give the legal aid to the poor people and vulnerable sections of the society, when he is supposed to give the legal aid to the women, children, Dalits, and elderly people and disabled people, when the 12 schemes have been put on the website of the NALSA. So when the legal aid is supposed to do a Herculean task like this, then why the teacher should not be empowered? Then why there should not be a substantial budget for the legal aid? Why the legal aid clinic should not be taken seriously? And I'm so sorry to say that in India, except only few law colleges and universities, the legal aid clinics have not been taken seriously. And my argument is that there should be a policy change. There should be a policy change. When the Bar Council of India under the legal education rule says that there should be a legal aid clinic in every country, whether the Bar Council of India do some homework, whether it monitors whether the legal aid clinic is working properly or not, whether the Bar Council of India is not aware when it does an annual inspection, only on that day the door of the legal aid clinic is open, whether this reality is not known to the authorities or the members of the visiting team, whether these ground realities is not known to the honorable members of the Bar Council of India and the State Bar Council of India, whether this reality is not known to them. This reality is known to them, but they are not serious about this institution. And that's why this is my humble expectation from the authorities and Bar Council of India and the Vice Chancellor of all the National Law School and the deans and directors of all the legal institutions, that the legal aid clinic should be taken seriously. Their volunteers must be taken seriously. Their faculty members should be taken seriously. Some substantial financial budget must be given. Without the budget, how the legal aid clinic can function? This is my argument. Otherwise, we should not talk about the right to legal aid. And therefore, my certain other suggestions are that the ADR must be taken more seriously. Fundamental duty, we the people of India, we the citizens of this country must take our fundamental duty a little more seriously. Why students should not take this legal aid as their constitutional duty? Why the legal aid should not be a fundamental duty of all the students and teachers? And then lastly, I think that there is a need for empowering the faculty members for effective legal education. I'm so happy that the Amity National Law School or Amity Law University, Rajasthan, Jaipur, is organizing a fantastic program on access to justice and constitutional vision. And today I'm so happy to be part of this FDP program on day 3. And I'm so happy for the organizers. And I'm so happy to the Honorable Director and for the in charge of this program that they have given me this opportunity. I'm so happy that so many faculty members have registered for this program. And